Mr. Sloven.
Thank you, Mr. Chief Justice, and may it please the Court. Counsel, good morning. The trial court did not abuse its discretion in sustaining a blanket invocation of Fifth Amendment privilege on the part of Mr. Brown as relates to the entire subject matter of this case, which was a murder in which he was at least an accessory, may have been an accomplice and an aider and abettor, and according to Mr. Hurd, the defendant, he was the actual killer. That was Mr. Hurd's advocacy throughout the entire proceeding. I cannot think of and have yet to read or hear any proposed question that Mr. Brown could have answered where the answer would have been both relevant and not self-incriminating. And this is, I am taking a broad definition of self-incriminating as set out by the U.S. Supreme Court in Williamson, the link in the chain analysis. On the issue of Bedwell and Bowles, the trial court did not abuse its discretion in denying the request by Mr. Hurd to put Brown on the stand to have the jury witness his Fifth Amendment invocation of that privilege. That is not probative. It would have been wildly prejudicial, and it encourages flagrant manipulation of the trial process.
What effect does his testimony at the prior trial have in this, where he waived his Fifth Amendment rights to these items and then all of a sudden is asserting them?
In that prior proceeding, he waived his Fifth Amendment rights as to that testimony that he gave. However, and this was actually the defendant's advocacy below in his February 20th, 2017 motion to compel, quoting Kellogg, that the waiver of Fifth Amendment rights is specifically limited to the proceeding in which it happens. And this is true to the point where if you waive your Fifth Amendment privilege in a grand jury proceeding, in grand jury testimony, that doesn't bar you from re-invoking it before the trial on the same charges in the same proceeding. Now, I also want to point out that and the state tried to admit Mr. Brown's testimony from the prior trial. That was resisted by the defendant. The court ruled in the defendant's favor. The state attempted a discretionary review interlocutory appeal, and that was denied. If you want to take the approach from the Nesson and Liotta article that a Fifth Amendment invocation is probative only on cross-examination after direct examination, the approach that tries to maximize the amount of testable evidence before the finder of fact in the trial, then I would say that a Fifth Amendment invocation might then be probative to impeach the prior trial testimony. And I don't think that's an issue that's really before this court, but I want to contrast that use of the Fifth Amendment privilege against what Mr. Hurd is trying to do in this case, which the Nesson and Liotta article specifically disavows, says it makes sense to have a rule that a witness cannot be called for the sole purpose of having them invoke their Fifth Amendment privilege as to the entire subject matter of the case in order to ask the jury to draw a substantive inference of that witness's guilt from that invocation.
Can you elaborate on the improper gamesmanship or prejudice that would result if we allowed this?
Sure, and I think there's no better way to do that than to point at what's happened in West Virginia since Herbert. If you look at the citing references, there's a case called Markham. In Markham, there were three alleged accomplices charged as co-defendants in a murder. Their charges were severed for trial, and the defendant called each of the alleged accomplices co-defendants to the stand. And what the trial court did, complying with Herbert, was, and they had all said that they both said that they were going to invoke their Fifth Amendment privilege in a blanket invocation against the whole subject matter of the case. And the trial court allowed defense counsel to examine them by asking a series of argumentative questions, knowing the answer would be, I plead the Fifth, which to the jury sounds like an admission, sounds like the answer is yes, no matter what defense counsel says. And then the challenge on appeal is that the trial court abused its discretion by only allowing defense counsel to ask each of those witnesses 10 questions. And this is just flagrantly prejudicial. It's not probative in any way, because no matter what the question is, as long as it pertains to the subject matter of the case, that's going to be the answer. It doesn't establish the inference that defense counsel was trying to draw at all. But to the jury, it sounds like it does. I also want to draw the court's attention to Ohio versus Reiner, which we cited in our Notice of Additional The Nesson and Liotta article, if I had one criticism of it, it says that the best reason why a Fifth Amendment inference or invocation is probative as impeachment on cross-examination, impeachment of direct examination testimony, is because it establishes that the witness believes that the answer will incriminate them. Ohio versus Reiner says that that's not exactly true, that the Fifth Amendment invocation of privilege is available to a witness who, in their heart, believes that they are innocent, but believes that the fact that they would testify to if they answered the question would maybe cause a reasonable person to believe that they may be guilty. That would provide a link in the chain that would tend to support an inference of their guilt, or, lay the foundation for other evidence of their guilt. And the point here is that because a witness's belief that they are guilty is not a necessary precondition for their invocation of Fifth Amendment privilege, that means that the inference that you're trying to draw from that privilege, that the witness is not answering because they believe that they are guilty, right? That is just not supported in the law. Now, could you explain that to a jury? Maybe. But I think that you would start going into you'd be falling down a rabbit hole of legal concepts that, are difficult for us to even explain in conversation with each other, much less for trial attorneys and the court to present to a jury who is also tasked with finding the facts about what happened on the night of the murder. I also think that for any Fifth Amendment invocation by Brown to be considered by the jury, you would have to paint, and I know the Court of Appeals says in the unique circumstances of this case it has some probative value. I'm not quite sure what exactly that means, but I do know that if you're going to assess the probative value in light of the circumstances of the case, those are all things the jury would need to have. And I don't think we want the jury to have to hear facts about the entire procedural history of the case, including the fact that Mr. Hurd was previously convicted of first-degree murder, and especially when Mr. Hurd so aggressively moved to exclude all of Brown's prior trial testimony. That the idea of evaluating the weight of that invocation, independent of the prior trial testimony that Brown gave, I think is at best incomplete, and in reality probably wildly misleading.
Is this case controlled by Bedwell?
I think it is. Now, I know that the argument is that you could read Bedwell to create not a categorical rule, but to allow the trial court to exercise its discretion in determining whether to allow the defendant to call a witness for the purpose of putting the invocation before the jury. I don't read it that way based on the language used and based on the authorities cited that seem to create, those authorities create categorical rules, and the language says the court was correct, didn't abuse its discretion. But even if you read Bedwell that way, or even if you want to modify Bedwell to create that, I don't think you can find an abuse of discretion by the trial court here. You can find an exercise of discretion. The court specifically confirms with defense counsel that their advocacy is that the court has discretion to allow or disallow this. That's in the motion hearing. And then the trial court says, I think in the order it's very clear to see that the trial court exercises its discretion and says that this, under these circumstances, is not something that we're going to allow because it would not be probative here, it would be prejudicial, and I don't want to allow that drama in this case.
Would it have been an abuse of discretion if he had allowed it?
I think it would have violated Bedwell. I also think that it would have been problematic. I mean, I don't see it as probative. I see it as extremely prejudicial. So I would have viewed it as an abuse of discretion in that manner. I also think that it would be unfair to the state to allow that, because that it's really just not a testable inference to draw based on the already existing limitations on the evidence that the state could present. And all of the, when I look through the list of proposed questions, when I look at the resistance to the application for further review, all I see are questions that fall into two, maybe three categories. The first category of question that I see are questions that are designed to elicit from Brown admissions of guilt or facts on the way to admissions of guilt. Were you present? Did you have prior relationships with these people? Were you involved in these robberies? Your relationship with Stanley? Why were you holding the gun after the murder? All of these things, if answered, provide links in the chain tending to prove exactly what the reason why Mr. Hurd wants to ask them is because Mr. Hurd is trying to use those answers to prove that Brown committed first-degree murder. The other category of questions are where the answer would impeach Brown's testimony, questions about his mental health, his psychological background, and these are not relevant to prove that he committed the murder except through a prior bad acts inference. Their purpose is to impeach Brown's testimony, but Brown's testimony isn't coming in the first place. So it's not really relevant in that regard. The only thing we really have from Brown is the fact that he led people to the place where the murder weapon was hidden after the fact, which I look at as a blaring red flag that establishes the credibility and the reasonableness of his invocation of the Fifth Amendment privilege as to the entire subject matter of the case. And there's no impeachment by his prior mental health history that can undermine the fact that they found the gun based on the information that Majors got out of Brown and then reported to the police. So it's not like you can impeach that testimony regardless of what you say about how many times Brown was admitted to Broadlawns.
I ask you to move to the sentencing issue. If we agree with you on this Fifth Amendment issue, then we would have to deal with the sentencing issue. I tend to think that Mr. Dickey has a pretty good point that if someone is a juvenile, obviously under our case law, they cannot be sentenced to life without parole. If they're an adult, they will be sentenced to life without parole if convicted of first-degree murder. Doesn't that require that fact on which that difference in sentence turns, difference in punishment turns, have to be determined by a jury?
I think that would be an overextension of a lien and apprendi, that it's not an element of the offense, it's not a sentencing enhancement, it is a fact, if proven by the defendant, if established, that would lessen the minimum and maximum sentence. I would also point out, and I just want to make sure the court is aware, that in the motion in limine that the defense filed, I believe the date was May 11th, 17, on page 8, Hurd admits to his age. He says his birth date, February 11th, I believe, 1981. So it's not like there was an issue as to his age that was disputed. Additionally, on the remedy, if you tend to agree with the argument there, I don't think the remedy is to retry the entire case as to the facts of what occurred on the night of the murder. At worst, you would need a jury to find his age, but that's unconnected to any of the other fact-finding that the jury already engaged in. Now, I really do think this is an overextension of a lien and apprendi. I'm not aware of any court in the country that's found that age is an element of an offense like this, or that it needs to be found beyond a reasonable doubt by a jury. I think that the fact of minority age is something that the defendant can allege and raise, and if raised needs to be, I think it's something that the defendant has to show and not the state. And regardless of where the burden lies, it's not an element of the offense, not a sentencing enhancement. So it's definitely not something that falls under apprendi and a lien.
Isn't his age in the PSI, I mean, he would have been, 25, 26 at the time of the murder?
That's right. Yeah, and it would be in the PSI as well. And I know that the argument is that regardless of where else it was shown that he was entitled had a Sixth Amendment right to its determination by a jury, I just don't think it falls within the scope of a lien or apprendi. And I think that his he readily admits his age during the proceedings. I just don't think that it's an issue that he was entitled to a beyond a reasonable doubt finding on, and certainly not an issue that, if there is error, that would entitle him to relitigate the facts surrounding who committed this murder.
Maybe I glossed over it, but I know there's a difference between the emphasis of Fifth Amendment rights with a defendant who's actually on trial or has been charged versus a witness. In this case, does this witness, or at the time of trial, did he have any pending charges or potential charges, or is that part of the record at all?
He did not have any pending charges to my knowledge. I would point out that first-degree murder is a crime without any statute of limitations whatsoever. And that's why we included the second article in our Notice of Additional Authorities, Hernandez, where the court points out that regardless of and the court doesn't mention statute of limitations, but it is a murder case, and points out that there is, regardless of any pending charges or any resolved charges, there's a, I'm sorry, I see my time's expired. Thank you. There is a danger to the witness that if additional facts are discovered through their testimony or subsequently, that they may still be liable for first-degree murder. I think that same analysis applies here. Anything that Brown says that tends to show that he committed a willful, intentional, premeditated murder would tend to expose him to criminal liability. And I think the blanket invocation of privilege here is proper. Thank you.
Mr. Sloven, thank you as well. Mr. Dickey.
Mr. Chief Justice, and may it please this court, my name is Gary Dickey from Dickey, Campbell, and Sahag Law Firm in Des Moines, appearing on behalf of Kenneth Hurd, asking this court to reverse his conviction for first-degree murder. Mr. Hurd denies that he is criminally liable for the death of Joshua Hutchison. Instead, he insists that Mr. Hutchison was murdered by Marco Brown at the behest and direction of Dylan Stanley. There's certainly enough evidence, as Judge Gamble pointed out in the post-conviction relief ruling, to support that theory. First, Stanley had motive to murder Hutchison because he was pursuing Mr. Stanley's girlfriend romantically. Stanley and Brown were close associates. Stanley admitted to telling Mr. Brown to either mouse or mouth Mr. Hutchison the next time he saw him. There's evidence in the record that Brown had the murder weapon both before and after the murder. And then there is a jailhouse conversation where Mr. Brown is overheard telling Hurd, I know you didn't do it, let me play crazy for a while and then I'll come assist you. So there is more than sufficient evidence in this record to conclude that Mr. Stanley and Mr. Brown were the perpetrators of the murder. Unfortunately, because of ineffective assistance of counsel at the first trial, that theory was not adequately presented, and because of the rulings of the district court, Mr. Hurd was not able to present that theory of defense adequately on retrial. So there is...
Doesn't that kind of support why Mr. Brown needs that blanket privilege, everything you just said?
Absolutely. We don't suggest that he was asserting Fifth Amendment in bad faith. He absolutely had a right, and should proper counsel should advise him to assert.
So we boiled it down to whether or not you can put him on the stand in front of the jury and talk about, I take the fifth, I take the fifth, I take the fifth.
Well, there's two aspects to this. First is whether or not he gets to invoke a blanket invocation. That's where the Court of Appeal said under the unique circumstances of this case, and they're very unique, that was error. The other aspect to it is whether or not you can force a witness up on the stand to repeatedly assert that invocation in front of a jury. Either way, if this court finds that the district court erred, Mr. Hurd's entitled to a retrial. I would submit to this court that it ought to re-examine Bedwell. Judge Blink at the district court level certainly thought that it was a blanket rule. If you look at the case upon which it relies, the federal case Bowles, that has not been routinely or uniformly followed. There's the Gray case that we cited from Maryland, and that's really, I think, the framework that this court ought to consider, which is if there is evidence that the witness is implicated in the crime and the court makes that determination, then a defendant ought to be able to call that witness and require that witness to invoke the Fifth Amendment during trial. And that's where we depart with the state. That is not highly inflammatory. If this was a wrongful death case, a civil wrongful death case, Mr. Hurd would have been able to call Mr. Brown before the jury and ask those same questions.
Is that what you call the unique circumstance, the fact that Brown, there's some evidence implicating him as the murderer? Is that the unique circumstance, or is the unique circumstance that there was a prior trial and he testified?
Both would be unique circumstances. So this is what I would consider what we call a boxed murder, right? So we know there's a murder that's occurred and there's only a few possible combinations.
Separate the two. I mean, witnesses have given prior statements all the time and then decide they're not going to talk at trial when it comes to trial. I mean, maybe not in the form of a prior trial, because there usually aren't two trials, but you'll have prior statements. That doesn't seem to alter the normal rules that you can't call a witness in front of the jury just to get them to invoke the Fifth, does it?
Well, I would point to a third unique circumstance, which is the ineffective assistance of counsel in the cross-examination at the first trial. I mean, if we were to back that out, I think the position that Mr. Reset would have taken at the district court would have been different. We would have wanted Mr. Brown's first trial testimony to be admitted if cross-examination had been adequate, and then the jury could decide from that. So,
but probably the state would have wanted that too. I mean, I think they probably felt pretty good about their first trial, but it is what it is. The remedy for ineffective assistance is a new trial, not to change the normal rules for the second trial, is it?
Well, 2 points to that. First, it's not the same. The state had the ability to compel Mr. Brown to testify. They could have granted him immunity, at which point he has no Fifth Amendment jeopardy, and so he could be compelled to testify. So there is a lack of symmetry in the interest of having Mr. Brown testify at the second trial.
Were they required to grant him immunity?
No, they weren't required. There is some case law that would suggest that a defendant, under the right circumstances, could request judicial immunity from the judge in a situation like this. That was not done here, so the record isn't preserved. Certainly that would be something explored.
Following up on Justice Mansfield's question about what else is unique here that would justify parting from our normal rule. You can't put somebody on the stand just to have them assert the Fifth in front of the jury.
Well, ordinarily that rule, that's not true in a civil context. So you could have that.
Understand that, and we're in a criminal case.
And the purpose for that rule in a criminal case is because there shouldn't be a penalty to that person for asserting his or her constitutional right. And there is no penalty in this case to Mr. Brown by having him testify and assert the Fifth in front of a jury in Mr. Hurd's case. So that's a unique circumstance. But to get back, this is a box murder, so it's not a situation where Mr. Hurd could have went out and brought in somebody who was not part of this of the evidence, and to fabricate and partake in some gamesmanship to get up and assert the Fifth frivolously, so that the jury may think that some unknown person. So it's either Mr. Hurd, Mr. Brown, Mr. Finley, or a combination of them that would have perpetuated this murder. And so under that circumstance, under the Gray analysis from Maryland, if there's strong evidence or if there's sufficient evidence to suggest that Brown would have perpetrated this murder, then he should be required to assert the Fifth in front of the jury.
If the state, if his prior if things had played out differently, wouldn't the state have then tried Hurd as the alternative theories as an accessory or accomplice? Or
they could have. They did not pursue an aiding and abetting theory until they got to the jury instruction stage. And at that point, Judge Blink said that he wasn't going to allow the theory to be tossed in there at the 11th hour.
I have a question. Let's say I know your client had a right, an absolute solid, rock solid right to not testify. And the state cannot even have an instruction to that effect that, hey, did you notice he didn't testify? I mean, that would be reversed all by itself. Okay, so your guy doesn't want to do it. If we say it's okay to make somebody else do it, and let's say he does get charged, are they going to try and bring up his prior testimony, take the Fifth, take the Fifth, take the Fifth?
I don't believe in a subsequent trial Mr. Brown's invocation of the Fifth would be admissible against Mr. Brown.
You believe, but if you were that guy's attorney, would you want to gamble with that?
Well, that's not briefed. I'd be happy to provide supplemental briefing, but I think this court has consistently said that there will be no penalty for asserting a constitutional right, and so that it should be excluded at a trial against Mr. Brown.
It may not be briefed, but my point is trying to get to the justification of Bedwell and perhaps some of the dangers of having someone do that.
Again, I understand there is a concern that there could be some gamesmanship, bringing somebody in to kind of be a patsy to take the Fifth frivolously so that you could argue in closing argument. that's where you get into the gray framework where district court has to take a look at that and see if there's...
I mean, I don't know. It just, you say unique. This just doesn't strike me as that unique a situation. You have several people that are involved in the incident in various different ways, some of which the state is able to get to testify, some refuse to testify, and everybody deals with that. I mean, how is this, I mean, it doesn't strike me as that unique a situation, is it?
Well, I would point to 4 factors. First, it's a boxed murder. Second, you have Mr. Brown's prior testimony, which if he stood trial, Justice Christensen, if he stood trial, they could use the testimony from the first trial against him. So that's unique in that aspect. You have evidence, you have sufficient evidence in this record to suggest that Mr. Brown may have been the principal that committed this murder. And then you have the ineffective assistance of counsel, which hamstrings the second trial counsel's ability to use the testimony from the first trial. Frankly, I don't know how Mr. Reset uses the transcript of Brown's testimony from the first trial, in which there was inadequate cross-examination, and doesn't walk himself right into an ineffective assistance of counsel claim after the second trial. I mean, I've tried to come up with a scenario in which he could do that, and I don't know how you do that if the first cross-examination was inadequate and Mr. Brown is not available to testify at the second trial.
Mr. Dickey, in a civil case, when someone takes the fifth, it's presumed that the answer would be against their interest, and that's how the evidence is handled. If you ask Mr. Brown in this criminal trial as a witness, outright, did you murder so-and-so? And he says, I take the Fifth Amendment. I mean, you may not get the instruction as in a civil case, it's a presumption against your interest, but you're sure creating that presumption. I mean, that if he's going to take the fifth, that's the question I'd ask. And then I'd argue to the jury, he didn't answer it. That means he probably did it. I mean, is that really fair?
Yes, it is. I mean, Mr. Hurd has a Sixth Amendment right to cross-examine witnesses and to present evidence at trial. And if his theory of defense is that Brown committed the murder, that's the best way of demonstrating that he did commit the murder. Now, the question is it relevant? Sure, it's relevant. Is it prejudicial? Sure, it's prejudicial. It's probably the most prejudicial evidence. Is it unfairly prejudicial? And the answer is no, it's not, particularly when there's no penalty to Mr. Brown. If we're not going to use it against him in a subsequent trial, or he's already waived his Fifth Amendment, and so he's made admissions in the first trial that can already be used against him, there's no argument that there's no reasonable argument that that would be unfair to either the state or to Mr. Hurd.
I see the floodgates opening. Every co-conspirator criminal case, they're going to run to the courthouse. I want trial first, and I'm going to call my co-conspirator to the stand, and I'm going to make him take the fifth in front of everybody. Isn't that going to be a mess?
Well, there would have to be a basis for severance of trial. So if it's a common nucleus of operative fact, they're going to be tried together, unless there's some brutal issues. And
well, in my experience, they're oftentimes separated.
Sure. And then, well, so then if there are brutal issues, then you've got you probably have other statements from your co-conspirator that may be independently admissible. But that's why I would advocate this court adopt the gray framework, which is there has to be the first step is some type of credible evidence that your co-conspirator was a principal in the offense.
So if I understand you correctly, the reason you want to put Brown in front of the jury is and take the fifth in front of the jury is so that the jury thinks he did it, not Hurd. And yet we don't allow that. We wouldn't allow the state to do that to Hurd.
Right.
And our long line of precedent in most jurisdictions is you can't put somebody you know is going to take the fifth, you don't put them on the stand for that. And that the defendant's right to confront witnesses is trumped by the witness's right to invoke the fifth. So wouldn't this be a sea change in our law?
No, that's a fundamental difference is when you call Mr. Hurd in front of the jury and he asserts the fifth and they imply that he's guilty, then you are punishing Mr. Hurd at his own trial. When you call Mr. Brown at Hurd's trial, there's no punishment to Brown so long as it's not admissible at a subsequent trial, and that's when you would deal with it, right? You would keep it out at that point.
And that's why we're going to get into the situation Justice Christensen identified.
Well, what I could say, I guess, then is that, Iowa is different, and we cited this in the Cashin decision. We have expressly recognized a state interest in avoiding people being wrongfully convicted. I'm not sure that's recognized in any other jurisdiction. And so when you are weighing Mr. Brown's invocation of his Fifth Amendment right against Mr. Hurd's Sixth Amendment right under these unique circumstances, I think it deprives Mr. Hurd of the central theory of his defense and the most important piece of evidence to support that, to not allow Brown to...
Would it really alleviate wrongful convictions? I'm trying to think this through. I mean, you have a coherent approach. It's just not consistent with what I'm used to. If you win an appeal, then the state may well grant immunity to Brown for the second trial. And then he, even if he is the guilty party, as your client contends, he never will be convicted. Does that really alleviate the risk of wrongful convictions?
Mr. Chief Justice, my time's expired. May I answer that? I would say if first of all, Mr. Brown testified in the first trial, okay, and didn't, so you have that testimony already. But I would say that on retrial, Mr. Hurd's theory would be Dealin Stanley is the one with the motive, and Brown is the means by which he committed the murder. And there is all kinds of evidence to support that. If Brown wants to get up and say, I wasn't the one who murdered him, then that's a credibility determination that should be made by the jury. If he wants to get up and he wants to say, I assert the Fifth, then that's an issue of fact that the jury should be able to consider when considering Mr. Hurd's guilt. Either way, Hurd would be in a far better position if he either testifies or he's compelled than what he was at the second trial. So for those reasons, we would ask this court to reverse his conviction.
Mr. Dickey, thank you. Rebuttal?
Thank you, Mr. Chief Justice. So what I heard multiple times is that there's no penalty for Mr. Brown for this invocation at Mr. Hurd's trial. That's the reason why this is ripe for abuse. Because Mr. Brown would face no penalty, Mr. Hurd would be able to point to Mr. Brown as the killer. He could argue that to the jury that this is what the invocation means, and if he was innocent, he wouldn't have pled. And the reason it's unfairly prejudicial is because we know that's not what it means, but that's the inference that a jury would automatically draw. And then at Mr. Brown's trial, who takes the stand and pleads the Fifth? Mr. Hurd. Now, the argument is that that won't be possible in a joint trial.
You cure that with a jury instruction?
You might be able to. However, the argument that's being made is that the jury would draw an inference against Mr. Hurd from Mr. Brown's absence in defiance of instructions to the contrary, that the state has the burden. So if the entire argument is predicated on the idea that juries don't follow instructions, and then you're saying you're going to remedy the problem with an instruction, I just don't see how it follows. The existence of this tactic will require severance of multiple co-defendants so that it'll create essentially a Bruton issue or a quasi-Bruton issue where they say I want to introduce my co-defendant's confession in the form of their Fifth Amendment invocation on the stand. And so we arrive at this place where I really do believe that you're correct when you say that the floodgates will open. Now, the argument is that the state...
Do the opposite? I mean, wouldn't the state want to always have a joint trial because then they wouldn't have this problem?
Well, I think that when the defendant says, I have a Sixth Amendment right to present this evidence and a joint trial would prevent me from doing so or prejudice my co-defendant and vice versa, right? That's the Bruton issue that would require severance, just presented in a different context. The state wants a joint trial, but would never get one.
Well, Mr. Sloven, as in so many other cases, we're dealing with competing rights here. We have the self-incrimination and the right to compel witnesses. And so Bedwell gives us our per se categorical rule. We just know. But, Mr. Dickey says, well, we have some special circumstances, and the response is, well, this is going to open floodgates, it's going to do all that. Well, what's wrong with a rule that just gives the trial court the discretion to make those judgments, to determine if there is a special circumstance, to determine that the floodgates don't open, to guide this situation, since we are dealing with two powerful competing rights?
I have a couple thoughts on that. The first is I don't see any special or unique circumstances here. We're dealing with a second trial. I know the resistance says this is the state's star witness. Not at the second trial. The second trial proceeded entirely on other evidence. And look what the jury found.
Well, couldn't the trial judges make that call and tell the trial counsel, there's nothing special here, I'm not going to allow you to do it?
Right.
And we're done.
A, I think that's what the court did here. But B, the reason we have categorical rules regarding admissibility of evidence is because we make a judgment that across the board, this is the kind of evidence categorically that has that is always unfairly prejudicial, always inflammatory, and lacks probative value. And that's exactly the kinds of things that are already in our case law concerning the inferences that you can draw from an invocation of Fifth Amendment privilege. And on the topic of the competing rights, that's why we put U.S. versus Roberts in our notice of additional authority, because of its observation that the Sixth Amendment right, the right to compel witnesses to appear, that's aimed at allowing defendants to produce admissible evidence at trial in their defense. And if this doesn't result in the presentation of admissible evidence that's probative enough, evidence that lacks this unfair prejudicial value, then there really isn't a competing constitutional interest at stake. And State versus Countrymen is, I go back to this one a lot, where the court says it doesn't violate due process to apply even-handed evidentiary rules evenly to both parties aimed at maximizing the relevant evidence presented and excluding prejudicial evidence.
Did Judge Blank, in looking at the transcript of the argument, he uses the word discretion repeatedly. Is there any need to send this back for him to exercise his discretion, or has that already happened?
No, I think that Judge Blank indicates not only that he relies on Bedwell, but also that he finds Bedwell persuasive as applied to the facts of this case, and says, in this instance, I'm uninterested in allowing this Perry Mason moment, that it may be good theatrics for the jury, but it doesn't have the probative value that Mr. Hurd wishes to assign to it, and it would not aid in the actual fact-finding inquiry that the jury has to perform. Thank you.
Mr. Sloven, thank you as well. Mr. Dickey, thank you again. The case of State versus Hurd then is now submitted, and I'll ask the bailiff to adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.